Peace, world peace. Welcome back to Goddess Dawn Speaks, aka the $1 Trillion Goddess. I am Goddess Dawn, and I'm back. I am live. It's a kind of a strange live because it's just like 2:20 in the morning Pacific. I'm up. I noticed that there was this response from the government to Tory. I'm sorry, Tory Lanez has been on the brain. To Diddy's last 4 court filings. The government responded to all 4 filings in one response. Being that I can't sleep and I was going to sit up and read this, I decided to just come here live and read it. You can sit back and chill and listen to the government response. Feel free to come back to the replay, but just know that it'll be here for whenever you feel the mood, because I know that to be in the mood for Diddy, you know what I'm saying? It's not always something you probably want to think about. I'm actually over it, but we got to see this through, right? All right. So, again, what I'm going to be reading is a court document filed yesterday, October 30th, United States of America versus Sean Combs, aka Puff Daddy, aka P. Diddy, aka Diddy, aka PD, aka Love. Defendant. The government's opposition to the defendant's motions for a hearing, bill of particulars, and gag order. Okay, let's get into it. And there's 53 pages here, but the first 10 are indexes noting the court cases that have been cited, as well as the printed articles or posted articles that have been cited. So I'm going to start with the preliminary statement. Okay, so it says the government respectfully submits its response to a series of motions filed by defendant Sean Combs since he was indicted by a grand jury sitting in this district little more than 1 month ago. His motion for an evidentiary hearing, among other relief, in response to purported leaks, the leak motion, his motion to require the government to identify victims, which is the bill of particulars motion, and his motion for an order prohibiting extrajudicial statements from civil litigants, and that would be the victim gag motion. First, the court should deny the leak motion for the simple reason that the defendant fails to show any grand jury material and that there was a leak. Without any factual basis, the leak motion seeks to suppress highly probative evidence, a video of Combs brutally assaulting a victim in March 2016 that was published by a media outlet in May of 2024, by claiming that it was a grand jury material leaked by government agents to CNN. So this is a very important item, because this is going to weigh out to the judge, for the judge to decide whether or not to allow the video of Cassie being abused by Diddy in that hotel hallway, something he has already admitted to, he has apologized for. Whether it was genuine or not, he is on film discussing, admitting guilt to this particular crime. And his attorneys want it to be struck from the discovery. They are saying that it was leaked by the government to CNN or the news source. The government is denying that, but they're telling them they don't have proof that it was leaked. And they say, but as the defendant is fully aware, the video was not in the government's possession at the time of the CNN publication, and the government has never at any point obtained the video through grand jury process. The defendant also complains about purported law enforcement sources leaking other alleged grand jury material to the media in several news articles cited in his papers and set forth in the attached table. Here, too, the defendant is grasping at straws, because the defendant cannot show that the information in the cited articles is grand jury material, and because he cannot show the government agents with access to the grand jury material leaked the information, he cannot make the prima facie showing required for the relief he seeks. Moreover, even if any of the information in the cited articles could be considered non-public information and properly disclosed, the defendant's request for relief under Local Criminal Rule 23.1 is mooted by the order entered by this court on October 25th, 2024. Second, the court should reject the defendant's bill of particulars motion as not only unnecessary but improper. As an initial matter, the defendant has been more than sufficiently apprised of the charges he faces, including through a 14-page speaking indictment, the government's submissions and statements on the record in connection with the defendant's bail hearings, and significant productions of discovery. And at the appropriate times, the accordance with the well-established practices in the district, the defendant will receive even more disclosures about the conduct in which he is charged, including through additional discovery, an enterprise letter, a witness, an exhibit list, and Jinx Act material. Accordingly, the defendant cannot credibly claim that he will suffer unfair surprise at trial. Rather, it is plain that the defendant's request for a bill of particulars containing victim names is merely a vehicle to attempt to prematurely restrict the government's proof at trial and use these criminal proceedings to defend himself in the press against complainants in separate civil litigation. The improper request would be denied in its entirety, particularly here, where there are serious and ongoing concerns for victim and witness safety, tampering, and intimidation. So they have some good points here, saying that the names that if they are provided to him, and in one case, the judge has already said that this particular defendant has to reveal their name or else the suit will be dropped. And I'm not sure which case this is, but I know that the judge already ruled on one, which could open the door for precedent for this to be applied to all of the accusers. But the government said that they could also use these names of these accusers to spread false information and misinformation about them in the press. Because as we have seen, Diddy's PR team is still heavily at work. A lot of the things going on in the media has to do with Diddy's side and Diddy's team putting things out there. And even though they want to accuse the government of leaking information, they could also be under suspicion for doing the same based on what we're seeing. For instance, I'm just going to say, there's a story out there that Adele, the singer, her either boyfriend, fiance, or husband, Paul Rich, the star sports manager, LeBron James's manager, and I think LeBron James have been outed by some PR person who I think used to deal with Adele. Basically, this person said that they're on the Freak Off tapes, all three of them. But, if this is the case, it's interesting that a story came out because you remember Adele used to be a bigger woman. I think she did the Ozempic thing, but she is much thinner now. However, there was a story that came out, I think the same day that this came out about these three, saying that there was a scale that the party planner had in case they needed to weigh women to make sure they were no bigger than 140 pounds. I thought that was really strange to be put out there. Like, why would this be a news piece? But thinking about it now, after seeing that the story about Adele came out the same day, seems to me that it could be Adele's people. Somebody is trying to put out their information so that Adele could be taken off that list. because the rumor has been out there about her. But if she was a bigger woman and she weighed more than 140 pounds, then that's to say that they wouldn't let her be in the freak off if she wanted to, and she was too big. But nevertheless, I'm going to go on. It says, finally, the victim gag motion should be denied as an attempt to backdoor the federal rules of criminal procedure to compel the government to prematurely disclose its witness list. Indeed, by seeking a preemptive gag order under the local criminal rule of 23.1, preventing potential witnesses in the criminal case and their counsel from making extrajudicial statements, the defendant is essentially asking a blanket order that would apply indiscriminately to any individuals with claims against Combs and their lawyers, or for a more limited order that would require the government to identify its witnesses 6 months before trial. Not only would such relief be unprecedented, but the defendant should not be permitted to use local criminal rule as a sword to gag civil claimants, whether or not their statements were connected to this criminal proceeding or to evade established case law in this circuit. Okay, so they don't want to give up these people's names. If they don't want to put their name out there, they should have the right to be a John or a Jane Doe, is what the government is saying, because of the potential risk to their eventual testimony. And they're saying that it would require the government to identify their witnesses 6 months before trial. Well, we're kind of already there. The trial is set for May 5th, 2025. So that means that they would have to give up the information by this month, right? Or December. I would say this month in order to meet that 6-month deadline. So this is going to be something the judge is going to have to weigh. So next on to procedural history. Let me look through this because some of this stuff I'm just not reading. It's just too technical, and I don't think, and nobody's out here combing through these lawsuits like they themselves are going to be at trial as the trial lawyer. I'm definitely not a lawyer. I'm not a legal expert of any sort, but I do like to read. I was an early reader. I'm an English major. I'm a writer. I'm all about the words. Okay, so let me see in this procedural history. It is okay. It's just summarizing some of the things in the indictment, but let me just start reading it, and I'll just skip things that I feel are too technical. All right, procedural history in or around November 2023, and as described in more detail below, federal prosecutors from the United States Attorney's Office for the Southern District of New York, working with case agents from the Human Trafficking Squad of New York Field Homeland Security Investigations, began investigating Combs and others for violations of federal criminal law. So they're saying they didn't even start investigating until November 2023, which is when Cassidy's lawsuit was filed. On September 2024, a grand jury returned a 3-point indictment charging defendant with racketeering conspiracy in violation of 18 USC, and then they list the violations: sex trafficking by force, fraud by and coercion in violation of 18 USC. That's count 1. Count 2 is transportation to engage in prostitution. And then count 3 is that's count 1 and 2. I'm sorry, counts 2 and 3. Transportation to engage in prostitution in violation of 18 USC. And yeah, so then it says, as alleged in detail in the 14-page speaking indictment, starting in at least 2008, the defendant participated with others in a racketeering conspiracy that he led and controlled, which is in parentheses, the Combs Enterprise. The defendant and other members and associates of Combs Enterprise wielded the defendant's power and prestige in the entertainment industry to cause female victims to engage in extended sex acts with male commercial sex workers referred to as freak-offs, which the defendant directed, masturbated during, and often electronically recorded. The Combs enterprise accomplished its goals through acts of violence and obstruction. With respect to the freak-offs, the defendant threatened victims with the electronic recordings of the sex acts as collateral. In addition, the defendant physically assaulted women and others by striking, punching, dragging, throwing objects at, and kicking them. Members and associates of the Combs enterprise also at times carried firearms, and on more than one occasion, the defendant carried or brandished firearms to intimidate and threaten victims and witnesses of his crimes. Further, when the defendant's power was threatened, the Combs enterprise engaged in acts of violence, including kidnapping and arson, and pressured witnesses and victims, including through attempted robbery, to stay silent and not report what they experienced or knew to law enforcement. On phone calls, the defendant and other members and associates of the Combs enterprise, among other things, provided these victims and witnesses with a false narrative of events in order to conceal the defendant's crimes. Following the return of the indictment by the grand jury, Combs was arrested on September 16, 2024. The next day, on September 17th, United States Magistrate Judge Robin Tarnowski ordered the defendant detained pending trial. United States District Judge Andrew Carter, to whom the case was then assigned, held another bail hearing on September 18, 2024, after which he ordered the defendant remain detained pending trial. In reaching his determination, Judge Carter stated that the defendant is a danger regarding obstruction of justice and witness tampering, and a danger to the safety of others in the community more generally. In the last month, the defendant has filed multiple applications for relief from the court, each one insisting that the relief sought was necessary and urgent. October 9, 2024, the defendant filed the leak motion seeking various forms of relief, including an evidentiary hearing, discovery, a gag order, and suppression of evidence. Then on October 15, 2024, the defendant filed the bill of particulars motion pursuant to Federal Rule Criminal Procedure 7, asking if the court require the government to identify the victim in the case more than 6 months before the trial. Finally, on October 20, 2024, the defendant filed the victim gag motion related to media statements from civil plaintiffs and their attorneys, seeking order prohibiting prospective witnesses and their counsel from making extrajudicial statements, among other relief. Okay, so that was just really a summary of all of the history about this case, how they began investigating, when they began investigating, when he was arrested, why he was denied bail twice before already, which is important because the bail hearing is supposed to be coming up with this new judge. So they, had to make sure they spelled that out. Let's see, background. The investigation of the defendant. Together, the case agents from Homeland Security HS1 or HSI New York. Federal prosecutors from the SDNY commenced their investigation into the defendant and others in November 2023. As part of the investigation and pursuant to the authority of the grand jury issued subpoenas to obtain evidence, including documents and other records, as well as witness testimony. To date, the grand jury has issued over 300 subpoenas, and the government has interviewed over 50 witnesses, several of whom testified before the grand jury. The government also took other investigative steps outside of the grand jury process, including obtaining a multitude of judicially authorized search warrants for, among other things, searches of cloud storage accounts governed by the Stored Communications Act, and searches of certain premises, persons, and electronic devices in accordance with Rule 41 of the Federal Rules of Criminal Procedure. Grand jury materials. The grand jury of the defendant proceeded in accordance with the rule of Federal Rules of Criminal Procedure, which governs, among other things, secrecy of matters before the grand jury and materials considered by the grand jury. For the purpose of this motion, the government attorneys, analysts, and law enforcement agents who have access to Rule 6E materials are referred to herein as prosecution team. And let me come real quick and make sure this video is still going. Okay. Throughout the investigation and in accordance with Rule 6, the grand jury issued subpoenas for various records relevant to the investigation, including inter alia, hotel records, travel records, financial records, and phone records. The records returned in response to those subpoenas were maintained pursuant to Rule 6E. At both Homeland Security New York and the Southern District of New York, access to the repository of electronic files containing grand jury information is restricted to the prosecution team. Specifically, at Homeland Security New York, the only three assigned agents can access all of this grand jury material. And if an unauthorized individual attempted to query or access the case file would appear to be empty or to the unauthorized agent. In addition, the lead case agent will receive a notification of the identity of the unauthorized agent who attempted to access the file. Ooh. So they have some security measures in place in case somebody tries to compromise or even look at the digital evidence. It seems they have it all tricked out. Okay, number 2, March 25th, 2024, search warrants. The government's investigative steps outside of the grand jury included numerous judicially authorized search warrants, including multiple warrants executed on March 25th, 2024 in Los Angeles and Miami. And this is the raids that we saw happening, specifically Homeland Security New York assistance of agents from local field offices executed search warrants on March 25th, 2024 at 3 locations: the defendant's Miami Beach residence, the Miami house, the defendant's Los Angeles residence, the LA house, and on the persons of the defendant and his chief of staff, which is that Christina Coram woman, KK, as they called her, at the Miami Opa-locka Executive Airport. So she was at the airport with Diddy. Yeah, there as well. So, I forgot to read the footnotes up here. So let me see. On October 25th, 2024, the court issued an order confirming the government's obligation as well as the party's obligation. Okay, so that's something that we can skip. All right. As of June 30th, 2024, federal agencies must maintain records electronically to the fullest extent possible. They refer to some archives and records administration memos. All right, I can skip that. Okay. The airport search, which was conducted after the defendant and others boarded a private plane bound for the Bahamas, began first on March 25th, 2024, and dictated the timing of the execution of the search warrants at the Miami house and LA house. Okay, so they're saying that that private plane going to the Bahamas, or about to be going to the Bahamas on March 25th, is what dictated when the fact that they executed search warrants at those houses. So basically just saying they were watching that plane, basically making sure that Diddy and possible co-defendants didn't skip the country. They say at both the Miami house and the LA house, Homeland Security special agents served as the team leader and multiple agents assisted in performing the searches. The team leader at each location had a copy of the applicable search warrant to leave at the location of each search, as required by the Federal Rule of Criminal Procedure 41, F1C. No copies of the affidavit setting forth probable cause were taken to or left at any search location. The team leader at each location also prepared an inventory of items seized pursuant to Rule 41, which was left at each premise alongside the team leader's copy of the search warrant. B. Discovery. Since the defendant's arrest a little over a month ago, the government has made 3 significant productions of discovery material, which include the following categories of materials: all search warrants and supporting affidavits, hotel, financial, and communication records produced pursuant to grand jury subpoenas, and electronically stored information from over 60 of the defendant's own devices and iCloud accounts, including, among other things, text messages, audio and video recordings, photographs, and documents, which the defendant had requested be prioritized. These materials contain additional details about the allegations against the defendant, including, for example, specific allegations relating to multiple victims in search warrant affidavits and communications with victims and witnesses from the defendant's devices. Okay, so they're saying that specific allegations relating to a number of the victims were in the materials they confiscated. They're saying that these materials that they confiscated, the video recordings, the photographs, the documents, contained details about the allegations and about the relating specifically to the victims, multiple victims. They say forthcoming discovery will similarly contain additional details about the alleged conduct, including additional communications with victims and witnesses, travel and hotel records relating to freak-offs, bank records showing payments to victims by defendant and entities associated with the defendant, and police and fire department records relating to the kidnapping and the arson discussed in the indictment. So they're saying this stuff is coming. Just give us time. Argument. Under the law in this circuit, all 3 of the defendant's motions should be denied in their entirety. First, with respect to the leak motion, the defendant has not made any prima facie, I think that's meaning on its face, showing of any leak of grand jury material. Consequently, the defendant's request for inter alia an evidentiary hearing and the suspension of a video showing the defendant violently assaulting a victim must be rejected. Second, the defendant's demand for a bill of particulars identifying the victims in the case fares no better because his request, made well before the discovery, is both premature and without merit. That is really true. It's very premature because they don't even have all of the discovery yet. So that makes sense. Finally, the defendant's request for what amounts to a witness gag order should also be denied because it's nothing more than another attempt to force the government to prematurely disclose its witness list and or to demand extraordinarily overbroad relief. Yeah, so they don't want to do it too soon. They're still working their stuff out and they're still logging and tagging and filing stuff and reviewing stuff and sorting things, matching things up to witness statements and things of that nature. Takes time. They just wanted to make sure he got locked up so he didn't flee while they were doing all this, because they probably wouldn't have arrested him so soon. So soon. All right. Let's see. The defendant is not entitled to the relief he seeks for purported leaks. In the leak motion, the defendant argues baselessly that a video depicting the defendant's assault of a victim at the Intercontinental Hotel at Los Angeles on March 5th, 2016, meaning the video, they call it the Intercontinental video, was provided to a media outlet by government agents. The motion logs alleged non-public information purportedly provided to media outlets by government sources in multiple news articles. However, the defendant cannot demonstrate that disclosure of any of that information in the cited articles, including the Intercontinental video published by CNN, was subject to the secrecy protections of Federal Rule Criminal Procedure 6E, or that any disclosure came from a member of the prosecution team. Accordingly, he is not entitled to relief. Okay, so now they're coming over. Hey, Queen Keish, Bianca, what y'all doing up? Happy Halloween. Hi, Rita. Good morning. Happy birthday. Happy birthday, Rita. Yes, everyone be safe out there. Halloween is crazy, y'all. Okay, so I'm just reading through the government's response to all of these motions that Diddy and his lawyers filed just within the past like week or so, and they responded to all four of these motions. What is this on the screen? They responded to all of the motions in one fell swoop. I don't know what this is playing. I had this video of Diddy playing in one of his parties. I'm gonna go back to that. Okay, so now they're talking about the applicable law, and they're talking about, why they need to. They're explaining why these leaks didn't come from them, and they're citing a Federal Rule Criminal Procedure 6E and the grand jury secrecy, and they're citing different cases. I'll just read a little bit of this. The proper functioning of our grand jury system depends on the secrecy of grand jury proceedings. Because absent that secrecy, prospective witnesses may be deterred from testifying. Those who do testify may be less likely to do so truthfully. Targets of investigations may flee, and persons who are subject of an ultimately meritless investigation may face public embarrassment. And this goes to Kalina, who was a band member of Dirty Money, the Diddy Dirty Money, who in yesterday's live, we showed her some of her interview that was recently dropped, which she defends Diddy, and she doesn't seem in her right mind, or she doesn't seem sober. I don't know. Alleged. I don't. I don't want any backlash from Kalina, child, but something wasn't right with that interview or with her state of mind, child. And she was doubling down on the fact that she didn't see nothing. My name is Bennett. I ain't in it. It was reported that she was actually called by Diddy when she was named in Don Richard's lawsuit to deter her from speaking out, and it worked. The very next day, she came out and said, "I didn't know nothing about this, and that it's not true." So what the government is saying here is full of merit, and hopefully it's considered by the judge. I hope they cite specific examples um, of so far what's happened that they know of where this is the case. And Kalina would be one of this. She would be one of the persons, one of the examples. So I'm going to skip down to the next section. So they talk about the local rule 23.1 and non-public information. So they're citing, more criminal law. Okay, I'm going down to discussion. I'm on page 22 of the filing from the government. The defendant is not entitled to the remedies he seeks, including suppression of evidence and an evidentiary hearing, because he has failed to make a prima facie showing. Number one, there has been disclosure of any of a matter or matters occurring before the grand jury, and two, that the source of the disclosure was an attorney or an agent of the government. They haven't proven it. They don't have anything to go on as far as that claim, is what the government is saying. Number one, they're talking about the Intercontinental video, which is a video where we saw Cassie getting dragged and kicked and stomped in the hallway of the hotel. Says that was neither grand jury material nor leaked by the prosecution team. So they were saying that this wasn't even presented to the grand jury. And without this, the grand jury still decided to indict him. So that says a lot. Okay, I'm going to keep that. Details of that we don't need to know. We just know that the grand jury never saw it. The defendant fails to establish that the cited articles disclose matters occurring before the grand jury. Okay, so they're saying that we didn't leak any information that was ended up in these articles that claim to have talked to a federal agent. Now the thing is, the New York Post had posted an article that stated that they had confirmation from a federal agent that the evidence that they have has lined up with the witness of the accusations that are hitting the public, these civil suits especially, but which opens up like accountability for him with regard to those civil suits, even though this is the criminal aspect. If if they are using the media to plant stuff, they could affect those civil suits as well. They could definitely use this stuff for their benefit. I think that it's very easy for the Post to be able to print a story and claim that a federal agent and working on the case told them this and told them that. But how do we know it's true that it was actual federal agent that told them this? And did they, behind the scenes to the government, provide who actually did speak to them? Because the New York Post, the media, they're protected. Their sources are protected typically, and so that's why they're such, I guess, a target for these leaks, because they know that whoever is giving the information to them, that they are not going to be able to disclose where they got it from. So let's see. It says number 2, the defendant fails to establish. Okay, so I read that already. Okay, so the searches of the defendant's Miami house and LA house and evidence recovered therefore are subject matter of the majority of the cited articles. The defendant has not and cannot establish that this information is protected grand jury material because the law is clear that information obtained through search warrants is outside of the scope of Rule 6 protections. The defendant's argument that the disclosure of information about the searches, including the target of the investigation, the types of search warrants obtained, and materials sought, and evidence obtained pursuant to search warrants, it somehow reveals the nature or direction of the grand jury proceedings is undermined by the very authority the defendant cites. And they're saying also, nor would this information constitute dissemination of non-public information in violation of Rule 23.1. All right, so they're putting the defense to work. They are citing a lot of things here that are going to have to be answered to if they want to get their way with these filings. Okay, I'm going to go down to the next section. The defendant cannot show that the prosecution team was the source of any improper disclosures. They don't have proof, yet again, that the law enforcement, there's any law enforcement connection with the prosecution, nor did the prosecution leak anything to law enforcement. Okay. Oh, Queen Keish, the movie, it's a video. I don't know why all of a sudden all these videos of Diddy and the kids and Diddy having a good time, or all these things, these nice boy Diddy videos have been popping up on my timeline. So I don't know if they're serving that up to me so I could chill on him or what. But this is a party, a New Year's Eve party that he and DJ Khaled gave together, I believe, 2017 going into 2018, I think. So I don't know what the movie was that was playing after this. I can't tell you that. Okay, I'm going to go back to the filing that I'm reading. Let me go down here. Yeah, so they're saying, Prosecution was not the source of any improper disclosures across the board, not to the media, not to law enforcement, not to anybody. They're saying where the sourcing is less clear, the courts are reluctant to draw the conclusion that the defendant leaps to here, that anonymous sources close to or familiar with the investigation must be the personnel conducting that investigation. Okay. They say none of the news articles or the letter indicates that a government attorney or agent was the source of the information, and at least one explicitly states that the U.S. Attorney's Office and the FBI, that the U.S. Attorneys. Okay, so they're saying they even said we declined to comment. Okay, I'm just skipping down. They're saying, with respect to the government's meeting with witnesses, multiple parties other than the government are aware of instances in which the government meets with witnesses, including the witnesses themselves, counsel for the witness, and any other individuals that the witness may choose to tell about the meeting. Any of those individuals, none of whom is within the government's control, could elect to disclose the meeting. So they're saying some of this stuff could have gotten out because we met with people and we don't have like a gag order on these people. So they can go out and tell whoever they tell, and they could actually leak things. It's not us, it's them. They said the same goes for information requested by the grand jury subpoena. Recipients of document requests via grand jury subpoena are not bound by secrecy requirements. So some people aren't bound by secrecy requirements that are dealing with some parts of the proceedings. Okay, I'm skipping down to the next section. See, the defendant is not entitled to the remedies he seeks. Same thing, really. I mean, they can't prove, they don't have any facts um, that anything was leaked, any grand jury material was disclosed. So they're saying he's not entitled to an evidentiary hearing because the defendant has to establish a prima facie case of a violation of Rule 6. The Second Circuit has made clear that the court may consider offered by the to rebut a prima facie case without holding. So they're saying we don't even need a hearing to deal with this issue. They're trying to avoid the hearing, apparently. The defendant also seeks an order to forbid the government attorneys and agents involved in the case from leaking any further information to the media. And they said it's a moot given that the court's order underscoring the parties' existing responsibilities under Local Rule 23. So the judge told both of the government and the defense that that they weren't going to do any gag ordering because they need to just follow the rules. If you follow the rules of the court, then nothing is going to happen. So let's just stick with that, is what the judge said. And the government is backing that up and saying, well, that's that. There's no need to further discuss it. The defendant's further request for other extraordinary remedies, including discovery, suppression of evidence, disqualification of witnesses, and even dismissal of the indictment, should be rejected out of hand given that he has failed to make a prima facie case for a violation of Rule 6E. Oh, so they wanted a dismissal as well as disqualification of certain witnesses. Mm. The defendant is not entitled to a bill of particulars, and this is identifying the accusers. By seeking a bill of particulars identifying victims under Federal Rule 7F, the defendant attempts to pervert the federal rules of the criminal procedure to unduly and prematurely restrict the government's proof at trial, and to co-opt the criminal proceeding to defend himself against complainants in separate civil litigation. The court should reject the misuse of 7F, particularly in light of the serious risks that identification of victims poses in this case, which, as the court is aware, involves serious allegations of violence, violence, witness intimidation, and obstruction. So they have applicable law that they're applying here. They said a bill of particulars is not a general investigative tool, a discovery device, or a means to compel the government to disclose evidence or witness to be offered prior to trial. So they're saying they're misusing this rule and basically bullying them in a sense to give up information that they're not ready to give because they're just not there yet and it's premature. So it could hurt their case should this be allowed. Yeah, they're going to lose. So their theory is that we're going to lose a lot of people. We're going to lose a lot of our testimony, our witnesses that we vetted. It's just not good. So they're telling us about the applicable law. Look at Joe Budden sitting right up under Diddy. This is why he was like kind of defending Diddy at first before the Cassie video came out. Joe Budden was one of those that we side-eyed because he was like, we need to wait and see, this is not true. He wasn't buying none of it. And now we see why they were in Revolt's bed together. Who was that behind Diddy? Oh, I thought that was Lorianne Gibson. I was gonna say, where is she? Queen said, I hope this is his last bell hearing attempt. Same here. Bianca, much love to all from Australia. All right. Everyone have a wonderful day on Halloween. You do the same. Thank you, Bianca. Wow. Okay. So part B, discussion. The motion fails under Local Criminal Rule 16.1. All right. As an additional matter, the defendant has not met the procedural requirements, and the motion should be denied on that basis. After sending a letter to the government October 7, 2024, demanding, among other things, the government identify its victims, defense counsel alerted the government on October 15th that they intended to file a motion with the court for the disclosure of victims' identities. The government promptly requested to confer before the motion was filed, as required. That afternoon, shortly before the motion was filed, the parties conferred, and the government informed the defense that it was aware of no legal authority for the disclosure request, but invited defense counsel to provide it for the government's consideration. The government further stated that any such request for disclosure was premature before discovery was completed. Defense counsel did not offer any legal authority, but instead informed the government it would proceed with the filing motion. So, see, and this is important because what the government is saying is that it was required by, the local rule that we meet before they file this motion to get these people's identities. So we had the meeting. And during the meeting, we told them that you don't have a legal authority for this. And if you feel that you do, show it to us. They're saying that the defense had nothing, but they said they were going to file anyway because that's the idea, is that I'm just going to file a bunch of stuff and spin the judge's head around and somehow just get him to agree. Maybe he'll miss it. So this is why the government this stuff out very specifically. And hopefully the judge reads every line of this thing, or if they have someone else doing it for them, and whatever way they get it done, hopefully they do a thorough job and don't miss this. Let's see. It says that shortly thereafter, so they filed the motion in good with the government in good faith, in efforts to confer with the government in a good faith effort to resolve the dispute. Number two, the defendant is not entitled to a bill of particulars. They're not entitled, they're saying, because the motion, they say, fails on the merits. There's no need for a bill of particulars listing victims' names here. The defendants have been more than sufficiently apprised of the nature of the charges. In the 14-page indictment, the government's written submissions and factual proffers, at least 2 separate bail hearings, and discovery produced to date totaling over 25 terabytes of data, including terabytes are huge. So 25 terabytes is a lot of stuff, including detailed search warrant affidavits, laying out details of the government's investigation and evidence. The courts have repeatedly rejected requests for bills of particulars where the defendant has received similar materials. And they've cited case law here. I'm going to keep scrolling. So in sum, the defendants claim that there is no way for Mr. Combs to determine who the other identified alleged victims are. They say it rings hollow. It rings hollow. They say that the indictment adequately advises the defendant of criminal acts which he is accused and accordingly of potential victims. So they said, what we put in that indictment is good enough. Like we gave you enough to know what you did, okay? So they're saying that I guess the whole thing that the defense is saying is that we don't want our client surprised at court. We want him to be able to have a proper defense. And the government is saying, well, based on what we gave you, you should be able to figure it out. There's no surprises. So all the different scenarios that were listed, and what they're saying is he should know what all of it is based on his memory. Let me go on. They're citing case law here. So they're saying the government will likewise. Okay, let me go up. Let's see. As is its usual practice, the government will file Rule 404B, notice sufficiently in advance of trial. The government will likewise disclose to the defendant at least 15 days prior to trial any witness testimony or other evidence it intends to admit under Federal Rule of Evidence 413. So they're saying we only have to give you 15 days, not 6 months. Giving them 6 months of time and the people's names, you know what could happen in 6 months? You have no witnesses by the time you get to your trial in May. Says separately providing the names of victims to the defendant now in particulars is not required. So get off of it. Number 3, any motion for a bill of particulars is premature. So again, they're saying it's premature, and they're citing case law to back up their claims. Finally, the government will produce to the defense a list of trial exhibits, a witness list, and Jenks Act material reasonably advanced of trial. They're going to give you what you need in enough time. There is no reasonable risk that the defendant will suffer unfair surprise at the trial. So that's the argument. There's not any surprises. You won't be surprised at trial if your lawyers are doing their job. They say that the motion improperly seeks to restrict the government's proof and poses serious risks of obstruction, just like what I said. 6 months is a lot of time to do damage. Okay, so basically they're saying rarely rejected, especially in light of risk it poses to witness safety. Yeah, they're just basically hammering down that disclosure of victim name poses serious risks based on the nature of the case, where the defendant is charged with engaging in a wide range of racketeering acts, including violence and threats of violence and obstruction of justice. The government should not be required to produce information that would, in effect, provide the defendants before trial with a preview of the government's case and its victims. Listen, I watch enough cop shows. I love Blue Bloods. I don't know if anybody else is a Blue Bloods nerd like me, but anybody knows who watches any of these types of shows that you cannot have your witness just willy nilly out and about outside before they testify in a high profile case. You got to protect these people. These people have to be sequestered. Um, yeah, I'm just I think that's going to be about it. Let's see. Here, as detailed in the indictment and at the bail hearings, the defendant has a significant history of violence and obstruction. Indeed, Judge Carter found by clear and convincing evidence at the conclusion of the second hearing, the defendant is a danger regarding obstruction of justice and witness tampering, and is a danger to the safety of others in the community more generally. Yeah, so they have already cited this in a previous filing. And they say, due to his history, the government has serious concerns about victim safety and the possibility and the well, they spelled it wrong, but possibility of witness tampering if a list of victim names were provided to the defendant. So this footnote says that the defendant is incarcerated should not affect this conclusion. The risk of obstruction is justice and witness tampering from prison, although reduced, is not non-existent. Yeah, he could still intimidate, bully, harass from prison. It says it's as detailed in the indictment, the defendant often used loyal intermediaries to accomplish his objectives, which he could do from prison or out on bail. There is no effective way to guarantee that he will not continue to attempt to do so, even from jail. Wow, so they really are saying that this guy, even behind bars, is using people there. He has loyal intermediaries, and they are doing his bidding. A bill of particulars would improperly restrict the government's proof at trial, and we already discussed that, and how detrimental it would be for them to get this information and have so much time before. Shoot, we might have some poisonings, some pneumonias, okay, we don't want that. So they're saying that, the defendant's request for the victim name should be denied on the basis that it's tantamount to a request for early disclosure of the government's witness list, something he is clearly not entitled to, and is extremely early stage of proceedings. Yeah. So they pretty much just kind of repeat certain things to, because it fits. So the law is not fancy. It's very straightforward. Let's see. They said Rule 7F is not a vehicle to respond to civil litigation. Even more unavailing is the defendant's argument that he needs victim identity so he can respond to the allegations made in civil suits. This court should reject this blatantly improper request. As previously noted, the proper purpose of a bill of particulars under federal rule is to provide the defendant with necessary information about the details of criminal charges against him, not civil charges. So all these civil suits that are hitting him from Tony Busby's office and whatnot, they're trying to conflate these two cases, or all the cases, including this one, and get certain things from the government to help them with their civil cases. And the government is like, no, 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 no. These things are separate. And we're dealing with the criminal charges. That's it. So they said it is not, however, a backdoor to obtain information from the criminal case so that the defendant can use it to defend himself in the media against in civil suits. So again, they know that Diddy's team has access to the media and have been using the media. Some of these stories we're seeing are from his team. That's why we see all these little silly stories every day, because they don't want us to forget Diddy, number one. And number two, they want to spin the narrative. They want him to be the good guy. Like I said, I'm getting these videos all of a sudden on my timeline. Oh, here's that other video again. I don't know what this is. Is that Bill Cosby? Oh, heck no. But I don't understand. So, they're literally they're thinking they're slick right here. Like, you're not going to be able to get something from us, information from us, so you can go and harass people and keep people from testifying. No, we're not doing that. Yeah, and you're not going to use the information to go deal with those civil suits. That's not our business, and that's not what we're doing here. The court should thus reject the defendant's inappropriate request for a bill of particulars. Now, lastly, the gag order, they say, should be denied, and the victim gag motion should, like the bill of particulars, be denied as a premature request for the government to identify and restrict its witness list over 6 months before a trial. Like, there's no way we're going to give you this list 6 months before the trial. Like, that's like right now we need to give you the list that we have. We're not even finished. They haven't even superseded his indictment yet, which they have promised to do. So it's just too early for the things they're asking for. And they're trying to hurry up and get a speedy trial. And they want to hurry up because they want to hurry up and get this done before the new charges come. Let's just keep it real. And they're probably pretty confident they will be coming. Now, I don't know how honest Sean is being with his lawyers, because he's the only one that really knows all the dirt he's done. And I'm pretty sure he's not sitting over there seriously self-reflecting and wondering, how did I get here? I'm pretty sure he knows exactly that that these things, well, I would say he knows exactly what he's done. So it says, let's see. They're saying the defendant seeks a blanket gag order that will prohibit any civil complainant, claimant, and their attorneys from making extrajudicial statements. So, like that Gloria Allred press conference, for instance, they don't want any of that anymore. Even Tony Busby, he, I think, would be included in this as an attorney. So to blanket it means that it's not going to just pertain to this particular criminal case. It's going to pertain to everyone, including the people dealing with these civil suits or putting them out. Finally, the defendant's suggestion that the government has directed or authorized prejudicial statements by counsel for civil litigants is baseless and provides no support for the relief he seeks. So they're saying that the government is working with Tony Busby, basically, and helping them with these civil cases. So they're saying all this stuff is crossing over. So I know Diddy's over there in jail with his head spinning. He got all these lawsuits coming in, and you know that he has to get these suits so he can read through them, and they need to be able to confer with him about them. And they're going to pick his brain and ask him, do you know who this is? Do you remember this? And I personally believe, based on just what I know about Diddy, is that he's going to deny probably that he had anything to do with any of these people. So I don't know, child. So that's pretty much the gist of the filing that the government responded to. What's up, Jason Finch? Happy Halloween. Who you gonna be for Halloween? R. Kelly? You believe Michael Jackson? Oh, you're gonna be Michael Jackson because you think he's still alive? You're gonna be out there doing the Thriller dance? Email me a picture. Goddessdawnspeaks at Gmail. All right. Well, that didn't take as long as I thought. That only took me like an hour and 5 minutes. So it's almost 3:30 in the morning. I guess I should finally hit the sack. I do have to get up early and take care of my dog. I have a beautiful dog, Queen. She's a boxer slash American Bulldog mix. She's so cute. And yeah, I got to get up and take care of her and get to work. Oh, you said, yeah? Okay, I'm looking forward to that picture, Jason. So, all right, Queen, Bianca, whoever's here, ever in the bushes. Thanks for hanging with me for this. And hopefully there's some clarity if you are actually interested in it. Because I know some people are kind of like, I just want to get to the trial or the verdict of the trial. Or are we even going to get to a trial? I don't know that we will. But if we do, I will be here with bells on. Okay, how do I? There we go. I will be here with bells on to bring the information. So until then,
Toodles, toodaloo, move around, go on somewhere, do you, get on, scat, bye, dip.